Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, hey, everyone. It is Monday, May 22nd, and that means we are less than 10 days away from our drop dead date as it relates to firearms with attached stabilizing braces, or what we call here the pistol brace rule. Now, despite the fact that there's been a lot of attorneys and a lot of politicians puffing their chest out talking about how they were going to stop this, and yes, we still have our fingers crossed on the case of Mock v. Garland and the May 24th date that is rapidly approaching. However, is it just possible that maybe we have gotten so spun up about something that can be so easily fixed? Is it possible that actually all these pages and pages and pages of word salad of rules, actually there is just a simple little solution? Well, maybe there is. I mean, if you take it straight from the horse's mouth. So today, let's spend a few minutes and let's talk about, did this guy actually give all of us an escape hatch on the pistol brace rule? Okay, so what we're talking about yet again today is ATF's new rule on firearms with attached stabilizing braces, which has its final drop dead date coming up in just 9 days. Now, as we know, and we're not going to rehash all of this, because if you're interested in a video about the countdown to the pistol brace rule, then you know what the hell's going on with the pistol brace. But here's what we need to know, okay, just to refresh a little bit of our memory, is that if we have a firearm with an attached stabilizing brace, we are essentially given 5 options here. Okay, the first option is we can turn the firearm over to ATF. Not going to happen. Not going to talk about that. Number 2, we can destroy the firearm. There is no reason to be doing that. Number 3, we can reconfigure the firearm. 1, we can take the shorter barrel off, add a new upper receiver to it with at least a 16-inch barrel. Rule doesn't apply anymore. We're free and clear. Or we can remove the stabilizing brace. Of course, the final option is we can do this amnesty registration, which I get that a large majority of you have zero interest in doing that whatsoever. And so what I am trying to do is come up with other ways by which you can avoid registering, which I get that, and yet remain compliant with the law, which may or may not be your desire. Now, we did a video way back in the day when we were still thinking about a Form 4999 and all of that garbage that, hey, wouldn't it be simple if we could just take the pistol brace off itself and that would solve it? And we figured that, hey, listen, if the rule is called firearms with attached stabilizing braces, then if we have a firearm that does not have an attached stabilizing brace, one would think under plain simple English that the rule no longer applies. When the ATF, however, published its final rule, and they gave us the options that we can do to remain compliant with this rule, the language that they used was as follows: permanently remove or alter the stabilizing brace so that it cannot be reattached, and thereby removing it from regulation as a firearm under the National Firearms Act. Okay, and of course, what got all of us spun up is permanently removed, because as we know, you can take a stabilizing brace off a firearm incredibly easy, but then of course it can be reattached with the same ease. So how does one permanently remove? Do we remove the brace and destroy the brace? Because if we do, we still have a firearm that readily accepts another brace. Do we remove the brace and then alter the buffer tube in some way so that no brace could ever be attached? And then how do we do that without changing the operational function of the firearm itself, and go on and on and on? And candidly, I can't comment on this because I am not a firearm expert. But you know who's supposed to be a firearm expert, actually, you would think that would be the director of the ATF. But as we know, back on April 26th, he had to go visit some people in Congress who were none bit too happy about this rule, including Representatives Thomas Massie and Jim Jordan. Now, an exchange occurred between Representative Massie and Steve Dettlebach, and candidly, I kind of wish that Representative Massie would have let Mr. Dettlebach actually answer a little bit more of the question, because I think we could have gotten even more valuable information. But the exchange that I want you to pay attention to is this right here.
And it was 120 days, is that correct? People are only felons if they intentionally. Is it 120 days? The law. I believe it's 120 days. So we've got 36 days left of the 120-day grace period. Can you tell us here today how many people have complied by registering this product? I am not sure of the exact number. I can check, though, and get back to you. There are people who are making applications. There also can be detachment. So in other words, we don't count, that's not for us to regulate. If somebody we wrote the rule to make it easy to comply with. If somebody just at their home detaches the weapon from the brace and keeps them apart, they do not have to register anything. They can keep the brace, they can keep the business end of the gun.
Okay, that's great clarification. So you're not going to do some kind of constructive prosecution where you say, oh, you had this and you had that and you intended to connect.
Keeping
they can just keep them
separately.
Them
as we
keep them separately. Okay, because that's not clear in your rules.
Okay, so it seems like if we just simply remove the brace, that's it. And as we all know, if you have just a rudimentary understanding of that particular platform of firearm, removing a stabilizing brace from a firearm is exactly this easy. So, is that all we need to do to comply with the rule? Well, according to directly from the horse's mouth, Steve Dettlebach, the ATF Director, the answer is yes. However, we take a look at the language in the final rule itself. No, it appears that there would be more. So how else can we connect some other dots here? Well, let's take a look at some of the frequently asked question sections because there were a couple of questions that also pertain to this subject matter. For example, one of the more common questions that was asked was, can I possess a pistol and an unattached stabilizing brace? Seems like a pretty simple question. And of course, that would mean like, well, then if I take the brace off, can I still possess my firearm and then just possess the brace and never the two shall meet again? Now, this was the ATF's answer, and this begins to add to everybody's confusion, because listen to what their answer is. An NFA firearm need not be assembled to be regulated as such. Whether a person may be in constructive possession of an NFA firearm depends on the facts of a particular case, which is ATF's way of saying we're not answering that question, but either because they don't want to or because they don't know the answer. Now, we could do a whole separate 35, 40-minute video about the law of constructive possession, but to put it in more simple terms, could you be, for example, in possession of everything it takes to make a machine gun and yet not have an operational machine gun, and ATF then decide that you, in fact, do have an operational machine gun? Yeah, as a matter of fact, we know that the ATF can do that with you just having a trigger and nothing more. So where we sit at this point is ATF Director says, yeah, just go ahead and take it off. Rule says, well, you can take it off, but you got to do much more than that. And then ATF also says, well, you know, if you got him, maybe you're not in trouble, but maybe you are. We can't really say. And candidly, that's not good enough. Can we find clarification anywhere else? Well, I took a look at another frequently asked question. Now, you'll see that we have to connect the dots on this a little bit, but I want you to pay attention to the question and then the answer, and you'll see what I mean. If I no longer want a short barrel rifle and I remove the brace, do I need to contact the NFA to unregister my SBR with an attached stabilizing brace? Okay. So this question is being asked as, I've already done an amnesty registration, I've got an approved amnesty form 1, but now I decide, you know what, I just want to go ahead and take the brace off and no longer have a firearm with an attached stabilizing brace. Can I just do that, or do I need to notify ATF? And ATF's answer is although it is highly recommended that you go ahead and take it off the registry for obvious reasons, no, it is not mandated. Which means that merely removing that brace on a now approved amnesty form 1 removes that as an NFA item. So therefore, why not would removing the brace also then just remove it from the purview of this rule? So what does this all mean to you? What is the crystal clear answer? I don't know. I wish I did. That's exactly what we try to do with this channel. But when you're getting conflicting messaging from the same agency, it's very difficult to predict what's going to happen. Now, We are coming into the last week and a half, and we know we got a big old 3-day weekend to end this thing, which a lot of you probably don't want to be sitting in front of a computer trying to register firearms with the ATF while everyone else is doing probably the same thing and the system likely crashes. What are your options right now as I see it? Yes, you can go ahead and throw them into the amnesty hopper. I get most of you are going to be in the comment section right away telling me I'm not doing that. I get it. You don't need to tell me that. That's fine. I just tell you what you can do. You decide whether or not you want to do it, okay? Can you at least take the upper receiver off, put a 16-inch barrel on right now? That absolutely positively takes you out of the purview of the rule. Would removing the stabilizing brace and just leaving it at that probably remove you from the purview of the rule? It is my professional opinion that it should, clearly under the rule of lenity. If we got into a debate about that, including what Mr. Dettlebach himself said, I think you would be on very solid legal ground. Would I keep the stabilizing brace and the firearm together? No, I probably wouldn't. I would probably remove the stabilizing brace to an entirely different location. So if for some crazy reason the two would never be discovered together by law enforcement. Let us remember now, we're still waiting on this case right here, Mock v. Garland, to determine whether or not we're going to have an injunction, and that is supposed to be set for a hearing on May 24th. I'm going to do a little extra research, see if there's been any movement on that, and obviously if there is, we will drop a video right away and let you know. This is going to be Pistol Brace Week. We're going to be doing probably video after video after video with little nuances, trying to keep you apprised of what's going on. We're not going to tell you what you guys need to do. We're going to give you, though, all the stuff you need to be thinking about so that you can decide what it is you want to do. Listen, in the meantime, if you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now, but if you don't, that information is right there in the description box. In the meantime, let's all remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.